everyone, this is Tina Newby with Florida Luxury Realty. Welcome to another segment of Tina Talks. And today I have attorney Sean Donovan from Butash and Donovan Law Firm joining us to kind of give his expertise on what's going on during COVID-19. So let us welcome attorney Sean Donovan. Hi,
Hi.
Sean.
Hello. How are you?
Good. How are you?
Oh, plugging away over here. You staying safe with the COVID-19
Yes,
pandemic going on?
trying, trying. How about you?
Doing the same. It's never a dull moment in the law business when you've got pandemics going on.
Right. So tell me, what have been the big thing right now during COVID-19 with family law? What's going on?
Well, with family law, there are a couple of main issues. First of all, several of my clients have asked me, do I have to participate in time sharing, which is what Florida calls custody or visitation, during the COVID-19 pandemic and expose the children, and then thereby also myself as the other parent to the COVID-19 virus, especially if the other parent is an essential employee working in, say, the medical field in an emergency room and having constant contact with people who may be infected with the coronavirus.
Okay, so do they have to do time sharing, or what's the big thing right now? What's going on right now that they need to be worried about?
Okay. Well, fortunately, the courts have answered the question for us. Both the Fifth Circuit, which is Hernando and Marion counties, and the 13th Circuit, which is Hillsborough County, have entered administrative orders related to this issue. The Sixth Circuit, which is comprised of Pasco and Pinellas counties, hasn't come out with an official administrative order, but the judges have completed video conferences with attorneys telling them how they're going to handle these types of issues. And all of the circuits so far are unanimous on how they're going to handle it. And basically, what it comes down to is that if you have a court order or you've entered into a parenting plan, that those are still in effect. And notwithstanding the fact that one of the parents may be in a high risk profession where they may contract the coronavirus, they still have the right to time sharing with the children. So you still have the obligation to participate with them and do the child exchanges and allow the other parent to have their time sharing unless they agree in writing that they will forego it. You can say, I'll give you makeup time sharing after the pandemic is over, or try and address it that way if it's important to you. But if the other parent is not willing to agree, then they do have the right to their time sharing. The one carve out, I would say, to that, as was expressed by a couple of the judges in the Sixth Circuit, is that there's one thing if you are an essential employee and you have to go to work. It's another thing if you are doing non-essential activities that are exposing yourself and then presumably the children to the risk of coronavirus by, say, going to parties or interacting with people when you don't need to. That could be an issue. And one of the main issues with that is attendance of church. And there was an issue not too long ago where a minister was actually arrested in Hillsborough County for conducting a church service when the Hillsborough County Sheriff's Department asked him not to. Then shortly after the arrest, the governor came out and said that people do have the right to attend church services. So that's something where the court was really not going to probably get involved with that, especially now that the few churches that I'm aware of who are actually having face-to-face services are doing it in smaller groups where there's social distancing and so forth, as far as I've heard. So that's probably not going to get you any kind of emotion that's going to get the court's attention and make them do anything to change time sharing. But other than that, if someone is doing voluntary activities that are exposing them to the risk, then you need to talk to a lawyer and see if you do have an issue that the court may want to hear about, and ultimately say that there would be no time sharing until the coronavirus pandemic is over or until some other period of time.
Okay. Also, what about child support? As we may know with the pandemic, a lot of people are out of work. They don't have the money. What do they have to worry about if they are a parent who have to pay for child support, but currently out of work and doesn't have the money? What do they need to do?
Unfortunately, I have several clients who are dealing with this issue, and they have either, they work in the restaurant industry or transportation industries, and they have been not even laid off, but just there's no business, and so they're not earning as much money, or they're not earning any money at all, or they've been laid off. And under those circumstances, while they're very sad, there is a mechanism there for help. The problem is, no matter how good the excuse that you have for having a reduction or elimination of your income, the court's not going to change your court ordered child support requirement until you let them know by filing a petition to modify. So once you file the petition to modify, so I'm telling the court, hey, I've lost my job, or I'm not making as much money, or maybe your finances are the same, but the children are not attending daycare anymore because of the coronavirus, which is a significant portion of your child support obligation that has now gone away. The court can go back to the date that you filed the petition and retroactively give you credit for, or relieve you of the responsibility of paying child support until the date of filing. But if you don't let the court know, then even though you can't pay, you're legally on the hook for the full child support payment until you file the petition to modify. So it's very important that you let your lawyer know as soon as possible, so that we can file the appropriate documents with the court to give you the best chance of having your child support obligation reduced or eliminated during this pandemic, until you get your job back and go back to normal.
Okay. Is there anything else that you've been encountered that, you feel like that people should know about, that they should reach out to you and your law firm so that they're not, in any kind of trouble with the law while this is going on?
Well, sure, there are a host of issues that go along with this pandemic, such as, curfews, and whether or not you can be out, where you can go, what you can do, where you can bring your children. Right now, the governor has entered a safer at home order. Uh, so that is less restrictive than a shelter in place order, which is possible could come down in the future. So everything that I just told you about, for example, the time sharing, could change if the governor changes his order from safer at home to shelter in place. Shelter in place, the Fifth Circuit has come down already and said, if the governor changes it to shelter in place, then the parent with majority time sharing will have the children full time until the shelter in place order is over, and then they can deal with makeup time sharing and so forth at a later time. But the other circuits have not made those determinations yet, but it would probably be about the same. So it's really important to you keep your finger on the pulse of, what the current status is of the pandemic, what our obligations as citizens are. And anytime you have any questions, you can give us a call here at Butash and Donovan, or call your own lawyer that you're familiar with and trust, and that we can give you advice and try and guide you through this very difficult time. It's very confusing, even for lawyers sometimes. So don't be embarrassed if you're not sure what the right answer is, because sometimes there really is no right answer, and you just have to go with what you feel is best. Sometimes there is a right answer, like in the two issues that we've dealt with here today.
Okay. Uh, is there anything else that you have encountered that the court is still kind of deciding on, or is it they're still trying to wait? What if the essential parent have most of the custody, but now, like nurses and doctors, what are they is there any special guideline for them? I've seen a lot of videos where, doctors and nurses are not seeing their kids or their family. How does that work into time sharing if they are the one that's having to go out and deal with this on a day-to-day basis?
Well, like I said before, right now there is no distinction between an essential employee who's out in the workforce and an employee who is either working from home or not working at all, and able to be with the children. Right now, the court is asking everybody to default to the court order or the parenting plan as to which parent has time sharing during which period of time, and that's the way it's supposed to go. Now, if a parent is, say, working in an emergency room and they themselves feel, I really don't want to put my kids at risk of getting coronavirus because I really have a high risk profession, they can voluntarily say, I'm going to let the other parent exercise my time sharing right now until things change, and then ask the court for make-up time sharing later, or enter into a written agreement with the other parent to get make-up time sharing at a later date when this whole thing is over.
Okay, okay. So then what about child support? Will that change any? Let's say, if the essential parent get the kid most of the time, now they have to work and then the other parent supposedly pay child support. Is it gonna be switch around or how does that work? Do they
It
have
absolutely might. It depends. There are several factors that come into play. Number one, when you're calculating child support, there are many factors that come into play. The largest factors are the percentage of time sharing that each parent has, and the percentage of the total income of both parents that each parent has. And child support is a math problem. So we can figure that out once we figure out what the agreement is, and then we can enter into a temporary change of child support during the pandemic, if the parties agree to. Frequently, parties will, under these kind of emergency situations, just agree to change the time sharing schedule and just not mess with child support. It's up to them. The courts like for the child support to be changed because the overriding theory is that a parent who's not spending time with the children has an obligation to support the children. So the parents may just do that on their own outside of an official child support guidelines, just give an extra $500 a month, or whatever is appropriate for their circumstances. But the more official you get it, the stronger it is if you're trying to enforce it later.
Okay. All right. Well, thank you so much for giving us a little bit of time and kind of help us guide a lot. I know a lot of parents are not really know what to do, and there's a lot of things that going around that, people need to know and have the information too. So I appreciate you.
It's my pleasure. Thank you for letting me tell everybody what's going on and how we can help them.
Thank you so much for your time. Thank you guys. I will go ahead at the end of the video. I will put Sean Donovan and his law firm at the end of the video, and you can give him a call at any time, right?
Great. Everybody stay safe, okay?
All right. Thank you so much.
All right.
Thank you. You have a wonderful day.
You too. Thank you. Bye bye.
Bye.